Hello friends, Namaskaram. Myself is Dr. Soni. I am an advocate in a defense counsel. Concerning the cases of disproportionate of asset, I will discuss one of the most important judgment of Honorable Supreme Court, wherein a great relief had been inclined to the accused. Judgment is dated 6th of August 2025. In that case, the accused was prosecuted as per section 13, subclause 1, subclause E of the PC Act. The said cases are concerned with DA cases. And finally, in the said case, the accused has accorded the explanation. The court observed that, as far as the explanation is concerned, two things are fundamental. Number one, the source, and number two, the authentication. And as far as the source is concerned, again, two things are fundamental. Number one, known source of income, and apart from that, the source must be legitimate. For example, there is a charge against a public servant that he interiorly acquired the asset of rupees 5 lakh by doing the criminal misconduct. If the public servant submits the explanation that there is no criminal misconduct, and apart from that, the asset is gifted to him by his mother, if the explanation is corroborated by the evidences, and if it is consistent, in that scenario, the public servant could have the benefit. So basically, the common mistake which we commit is that we never emphasize on the source, we never emphasize on the authentication, we never emphasize on the known source of income, we never emphasize on the authentication of the legitimate source of income. The result is that the court draw the presumption against you and ultimately you are convicted. But I want to clarify that judgment of Honorable Supreme Court is quite clear, which merely says the explanation is quite important. And even you will peruse section 13 subclause 1 subclause E of PC Act, you will find that the word is explanation. If the explanation is given and it is as per the norms and it is going to be corroborated with the evidences, in that scenario we could have the benefit. So the key point is the explanation of the accused. Please be noted. So basically we have to observe the income, we have to observe the expenditure, we have to observe the asset. If the proper accountings are not done, and apart from that there is inconsistency and there is lack of corroboration, then we could have the benefit. It is usually seen that number of flaws might be witnessed from the charge sheet of the concerned ACB or vigilance or CBI. The prime flaw is that they usually use the term income. I want to clarify that we have to use the term fund flow in place of income, because if you are going to use the word income, we are having the restrictive scenario, because income is the final outcome and which is also called the net profit. Whatever money is inter alia flow in our accounts is used to be consumed by us towards certain expenditure, and apart from that it might be the part of savings. In addition to this, it might be the part of asset. So basically we have to observe that in which manner the accountings are going to be done. So whenever we are going to emphasize on the income, I want to say that the fund flow, we have to emphasize that the fund flow might be from operations, it might be from finance, it might be from the investment. Operation means the earning of yourself through the business and by the way of salary. Finance means by the way of loan. Loan can be by the bank or by the individual. And apart from that, if you are having any investment, you purchased a property, and finally you are having the rental income, you are having the FDR, and you are having the interest income. In that scenario you could have the benefit, because basically we have to emphasize on the corpus of income. The more corpus we are having, the less chance will be to get the convicted, because the attack of prosecution will be that you are having more asset, more expenditure, and as compared to expenditure and asset, you are not having known source of income. So we have to specify them. You inter alia bypassed the basic principles of accounting and law. because the law says that find out the fund flow. And apart from that, we have to emphasize on the depreciation. And in addition to this, if we are having the known source of income, for example, our wife is earning, she is having the ITR, and despite of that, the income is not added, we could have the benefit. So basically, we have to emphasize on certain points so that we could give a plausible explanation. In the last, I want to submit that there is no presumption of Section 20 of PC Act. More specifically, in cases of Section 13, subclause 1, subclause E of PC Act, the prosecution has to prove the case beyond reasonable doubt. We are not supposed to prove our defense beyond reasonable doubt. We are supposed to give the plausible explanation so that we could create a suspect and could claim the acquittal. So basically, we have to follow all this fundamental while contesting the case of disproportionate of asset. See you in the next lecture. Till then, Har Har Mahadev, Jai Shiv Shambhu.